on Elizabeth Calhoun versus Alicia Levine and Travis Brown.
For the record, this matter is before the court. Subsequent parties have engaged in mediation with Ms. Stephanie Pratt from the front of the court this morning. Present is their attorney Christina Hills, representing the plaintiff Elizabeth Calhoun. And Ms. Calhoun, are you Elizabeth Calhoun, ma'am?
Yes, I am.
Right. Good morning. And ma'am, you are Alicia Levine, is that correct?
Alicia Levine, that is correct.
Levine, I'm sorry.
It's okay.
All the pleadings have L-A-V-I-G-N-E. If you've noticed that, but in any event, Travis Brown did not appear this morning. Is that correct, Ms. Hills?
That is correct, Your Honor.
Okay, the review of the court file indicates that the parties were to mediate today, and there's a parenting time review before this court on June 5 at 1:30, but the parties have reached an agreement this morning that will render unnecessary that review on June 5. Is that correct, Ms. Hills?
Yes, it is.
All right. Ms. Levine, is it correct that you've reached an agreement this morning with Ms. Calhoun regarding parenting time?
Yes, sir.
All right. All right, Ms. Hills is going to state that agreement on the record. Listen carefully. After she does so, I'm going to turn to you and ask you whether or not it's a correct statement of your understanding of this agreement. Okay, Ms. Levine?
Yes, sir.
All right, Ms. Hills.
Thank you, Your Honor. The parties have agreed that Ms. Levine will have unsupervised parenting time 1 day per month on a Saturday or a Sunday in Monroe County or Lucas County at times to be agreed upon by the parties. Visitation that Ms. Levine has currently at the center, I believe it's in Ohio, is going to be stopped after Ms. Levine's May 24th, 2024 visit. Any contact that Caden has with mom's child, initials S as in Sam, B as in boy, is going to be directly supervised by an adult. The first unsupervised visit that Ms. Levine will have will be June 2nd, 2024. Again, the time will be agreed upon. We are going to continue mediation with Ms. LaPratt on November 15th, 2024 at 8:30 a.m. Ms. Levine will have reasonable and liberal phone or electronic communication with Caden that will be outside of school hours. And if the contact occurred while Caden was doing his homework, then mom would be notified that Caden would call her back after the homework was done. And we would vacate the June 5th hearing. I believe that's the entire agreement.
Thank you. Ms. Hills, did you say there's another date the parties are going to mediate again with Ms. LaPrade?
Yes, I did. It will be November 15th, 2024, just prior to Thanksgiving.
What time?
8:30 a.m.
Okay, that'll be noted in your order then.
It will.
All right, thank you, Ms. Hills. Ms. Levine, did Ms. Hills accurately state your agreement this morning?
Yes, sir.
Wonderful. All right, Ms. Levine and Ms. Calhoun, can you both raise your right hand to be sworn, please? Ms. Hills, if you want to simply confirm this agreement with Ms. Calhoun, please.
Yes. Ms. Calhoun, would you state your name for the record, please?
Elizabeth Calhoun.
And have you heard the agreement which I just placed on the record?
Yes, I did.
And that was arrived at after mediation with Ms. LaPrade this morning?
Yes, it was.
And you were an active participant in that mediation?
Yes, I was.
You understand all of the terms of the agreement?
Yes, I do.
You understand what's required of you?
Yes.
Have you had enough time to think about all these issues?
Yes, I have.
And do you have any questions about anything that's been agreed to?
No, I do not.
All right. And do you believe at this point in time that this agreement is in Caden's best interest?
Yes, I do.
Thank you. I have nothing further.
Thank you. Ms. Levine, can you please state your name and current address for the record, please?
Alicia Levine.
Thank you. Obviously, it's important. You need to keep Ms. Hills and the Monroe for the court informed of any change of address, okay, in the future?
Yes.
All right, Ms. Levine, do you believe this agreement to be in the best interest of the minor child at this point in time? All right.
Yes, sir.
And, do you have any questions for Ms. Hills or any questions for the court?
No, sir.
Okay, Ms. Hills, do you have any questions for Ms. Levine?
No, Your Honor.
And Ms. Hills will prepare an order. Is that correct? And you send that to Ms. Levine. Are you going to submit it under the 7-day rule?
I will, and with the court's permission, I'll include a paragraph asking the clerk to correct the case caption to the proper spelling of Ms. Levine's name.
Okay, the correct spelling is L-A-V, capital V-I-N-E. Is that correct, Ms. Levine?
Correct, sir.
All right. Appears to have carried forward from
Probably from my initial pleadings, I would imagine.
Yeah, I'm not sure it went back to Adams County, but in any event, yes, if that would be wonderful. Ms. Hills, so mark on your calendar, first of all, Ms. Levine, Ms. Hills is going to reduce all this to writing. She's going to send you a copy along with a notice saying that'll be submitted to the court for entry unless you file a written objection within 7 days. So if you get the order, review it timely, quickly, and if there's a question, call Ms. Hills, okay? Maybe
Yes,
there's
sir.
a typo or something, but if it looks fine, nothing you need to do, and Ms. Hills will ultimately mail you a true copy after it's been entered. Note for your records that the review of June 5 at 1:30, that's off, so no need to prepare that date, but do put in your book this new date of November 15th at 8:30. It's a ways off. And that'll be in again with Mr. Pratt, Zoom and 8. That'll all be referenced in this order, okay?
Yes, sir.
All right. Again, Ms. Hills, you had no questions for Ms. Levine, is that correct?
Correct. Thank you.
Right. All right. The court would like to thank Mr. Pratt for fine assistance this morning, as well as, of course, Attorney Hills. The court finds, and it implores the two of you, the court finds agreement to be the best interest of my child. The court will accordingly enter the order and adopt the agreement upon presentment. Right. Thank you all. That will conclude, sir. You can all zoom out. Have a good rest of the day.
Thank you, too, Judge.
Thank you.
Thank you.
Welcome. Court will call the case of Amanda Eaton versus Tyler Eaton. This matter is before the court for a pretrial conference this morning. The same is being conducted via Zoom. Present is Attorney Alexis Spencer, representing the plaintiff, Amanda Eaton. Ms. Eaton appears to be present with Ms. Spencer. Good morning, Ms. Spencer.
Good morning, Your Honor.
In addition, defendant Tyler Eaton also appears to be present. Good morning, Mr. Eaton.
Good morning.
Great, Mr. Eaton is unmuted himself. Court's in receipt of a proposed consent judgment divorce. Right, Mr. Receipt, can you both please raise your right hand to be sworn, please? Thank you. Right, Ms. Spencer, you can begin with Ms. Eaton, please.
Thank you. Are you the plaintiff in this matter?
Yes.
Okay, and you filed the judgment, or the complaint for divorce?
Ms. Spencer, can you have her state her name for the record, please?
Yes, sorry. Can you please state your full name for the record?
Amanda Nicole Eaton.
Thank
Okay.
you.
And sorry, you stated that you were the one that filed the complaint for
Yes.
divorce? Okay. And prior to the filing of this complaint, were you a resident of Michigan for at least 180 days?
Yes.
Okay. And were you a resident of Monroe County for at least 10 days? Yes. Okay. And is it true that you were married in Petersburg, Michigan on September 12th of 2015?
Yes.
Okay. And is it also true that there are no minor children of this marriage?
Correct.
Okay. And I'm sorry, but I have to ask, are you currently pregnant?
No.
Okay. And do you believe that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Okay. And so you believe there is no chance of reconciliation?
No.
Okay. And then is it true that you are asking the court to enter a final consent judgment of divorce that you had previously signed?
Yes.
Okay. And did you have a chance to review that?
Yes.
Okay. And did you have a chance to ask any questions that you had? Okay. Did you understand everything?
Yes.
Okay. And is it true that you're asking the court to waive the statutory waiting period for the entry of this judgment?
Yes.
Okay. And then
Ms. Spencer, there is no statutory waiting period. 6 days have transpired. It's a deal case. So there's nothing, no statutory period to waive.
okay, thank you. Is it true that you are asking the court to waive spousal support as to both parties?
Yes.
Okay. And you understand that once that is done, you can't come back and ask the court to change that?
Yeah.
Okay. And then are you also asking the court to, for the 2023 tax year, that you and defendant are going to equally share any and all tax returns received?
Yes.
Okay. And then for 2024, you both will file separately?
Yes.
Okay. And is it true that you are asking to be awarded the all right and title and interest in the marital home located at?
Yes.
Okay. Regarding motor vehicles, is it true that you are requesting that you be awarded all right and title and interest in the 2015 Buick?
Yes.
Okay. And then defendant would be awarded all right, title, and interest in the 2016 GMC Sierra?
Yes.
Okay. Regarding personal property, is it true that you're requesting that you and the defendant shall mutually agree how to divide all of the personal property?
Yes.
Okay. For retirement accounts, is it true that you're requesting that each party be awarded their own retirement accounts free and clear of the other?
Yes.
And for life insurance, are you requesting that each party be awarded their own life insurance policies?
Yes.
Okay. For bank accounts, are you also asking that each party be awarded your own checking, savings, money market accounts that are in your own name?
Yeah.
Okay. And then you guys have a joint account at Glass City Federal Credit Union with a credit card as well, correct?
Yes.
Okay. And for that account, is it true that you're requesting that once you guys receive your 2023 tax refund, you're going to deposit it into that account and then pay off the credit card and divide the funds?
Yeah.
Okay. And as to debts, is it true that you're requesting that each party be responsible for their own debts in their own names?
Yes.
Okay. Have you given a full disclosure of assets and liabilities in this case?
Yes.
Okay. And are you requesting that you be allowed to restore your name to your maiden name anytime now or hereafter as you may choose?
Yes.
Okay. Is it also true that you're requesting that each party be responsible for their own attorney fees?
Yes.
Okay. And then, were you satisfied with my representation of you in this matter?
Yes.
Okay. And then do you understand that all of the property division in this matter, once the judgment is entered, can't be undone?
Yes.
Okay. And then, do you understand that you're waiving your right to a trial in this matter where the outcome could have been better, it could have been worse, it could have been exactly the same?
Yes.
Okay. And then did you have any questions of me or the court at this time?
No.
Okay. Nothing further. Thank you.
All right. Thank you, Ms. Spencer. Okay. You note that, Ms. Spencer, for the pleadings, we need to put east.
Just where I'm staying at right now. It's not like my actual, like I don't own the property or anything. It's just where I'm.
Ms. Spencer is going to mail you a copy of the judgment of divorce. We need to make sure we have an accurate address. And they're saying it's east. I was not aware there's an east and a west.
Correct.
All right. So for the next couple weeks, you can be the judgment will be mailed to you. I just want to clarify that for Ms. Spencer, so she has a correct mailing address, so it's not lost in the mail.
Okay.
Right. Mr. Eden, first of all, do you understand, even though Ms. Spencer is preparing this judgment of divorce, she's helping facilitate resolution matter. She represents your wife, Amanda. Her loyalties lie with Amanda. Do you understand that?
Yes.
And you've had the chance to consult with a lawyer if you chose to do so. Is that correct?
Correct.
Okay. And then did you approve this judgment freely and voluntarily?
Yes.
You heard the testimony this morning of your wife, Amanda, correct?
Correct.
Is her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions for the court?
I do not.
Do you have any questions for Ms. Spencer?
No, sir.
Ms. Spencer, do you have any questions for Mr. Eden?
I do not. Thank you.
The only question the court had is the marital home awarded to the plaintiff, Amanda.
Yes.
And Mr. Eden shall sign a quit claim deed if necessary. What about the mortgage? Is the mortgage in both names?
It is, but my client is going to be assuming that mortgage as well.
Well, I understand. But again, unless that lender releases Mr. Eden from the mortgage, which is very, very unlikely, Mr. Eden, you realize that's going to affect your credit until that mortgage is paid off. Ms. Eden is not required to refinance that mortgage.
Your Honor, we consulted with the mortgage company and they are willing to release him without a refi.
Okay, it's unusual, but Mr. Dean, you're aware, you've talked to the mortgage company, you confirm that they will release you?
I have. They said that they would let Amanda just assume the mortgage.
Well, but more importantly, will they take your name off it?
Yes.
All right, okay. I just that's most mortgage companies, lenders, they want as many names on there as possible. Just wanted to clarify that so you weren't surprised down the road. So thank you, Mr. Spence, for that clarification. And I just want to make sure Mr. Eden is aware of what he is agreeing to here. Very well. I would like to thank Ms. Spencer for her assistance helping facilitate resolution of this matter. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony has been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter, granting a judgment will enter, granting a divorce and bonds of matrimony. Excuse me. Right, the court assigned the judgment. That will conclude this hearing. You can all zoom out. Have a good rest of the morning.
Thank you, Your Honor.
You're welcome. We'll call the case of Dallas Sheehan versus Julia Borziak. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff, Dallas Sheehan. Mr. Sheehan appears to be present with Ms. Kuhn. Good morning, Ms. Kuhn.
Good morning, Your Honor. How was your vacation?
Wonderful, wonderful. In addition, Attorney Leslie Carr is present, representing the defendant, Julia. Is it pronounced Borziak?
Yes, it is.
Right, thank you. And Mr. Borziak is present. Good morning, Ms. Carr.
Good morning, Your Honor.
The court's aware we have a complaint for divorce and a counter complaint for annulment. There's a question as to the validity of this marriage, the ceremony between, the marriage between the parties, because there was never any ceremony. At least it's been alleged.
Correct, Your Honor. And the parties are in agreement. And we actually have a judgment of annulment that was prepared by Attorney Carr. And if I can put the provisions on the record, my client has signed it. I've signed it. I'm going to be emailing it over to Ms. Carr so that we can get it filed with the court.
Well, please, Ms. Kuhn.
Thank you, Your Honor. So basically, the judgment of annulment states that there's been evidence that this matter was not valid. You're correct, Your Honor. The marriage was not, the ceremony was not performed by a person that was licensed to conduct marriages. So it is void. We did put provisions regarding spousal support. Spousal support is barred to both parties. The marriage is annulled. We have language, property settlement, and provision in lieu of dower. We have a statutory insurance provision where each party would be awarded their own, free and clear of any claims of the other. Each party would be awarded all rights, title, and interest in any pension, annuity, retirement account, anything with regard to accounts, free and clear of any claims of the other. With regard to the annulment, there's one piece of personal property in dispute. That's the engagement ring. However, the parties acknowledge that if there's going to be any action for the return of that engagement ring, it would have to be filed in the proper court with jurisdiction. The parties understand that this court would not have jurisdiction. It could go to district court. They're on their own for that. Other than that, each party is awarded the personal property in their own possession, including vehicles, free and clear of any claims of the other. Each is awarded their own financial and bank accounts in their own names, free and clear of each other. They're responsible for the payment of debts in their own name. Obviously, they're responsible for their own health insurance, attorney fees as well. You know, I think the white elephant in the room, Judge, is that we will be back on a paternity action, provided that the child that the defendant is pregnant with is my client's child. My client is trying to keep in contact with the defendant. She shut him down from communicating because he wants to know about appointments, wants to know how the baby's doing. So I suspect that in August, when the baby's born, I will be filing an action. So I just kind of want to alert the court as to that.
Right, and the fact that the defendant is pregnant does not prevent this court from entering a judgment of annulment. Is that correct?
Correct.
That is correct.
All right. All right. Thank you, Ms. Kuhn. Ms. Carr, did Ms. Kuhn actually state your client's agreement?
Yes. And my client has also signed the judgment of annulment as well. So once I get Ms. Kuhn's copy, I'll be entering the same with the court. But we do agree that the marriage was void as it was not properly solemnized.
In other words, there was simply no ceremony.
There was no ceremony. My understanding is that someone signed the marriage license outside of the presence of my client, and it was somehow forwarded to the state of Michigan or filed in the normal way that marriage licenses would be filed.
Okay. In this, when the judgment of annulment is entered, it'll be then sent to the state of Michigan, correct?
Yes, we'll send it to the records unit, the vital records unit at the state of Michigan.
Right. Right. Perhaps the minister who signed this license should have known better. Maybe that person can address this dispute regarding the engagement ring. That person creating this mess. In any event, Mr. Sheehan and Ms. Borziak, can you both please raise your right hand to be sworn, please?
Yes.
Yes, sir.
Thank you. All right, Ms. Kuhn, if you can be with Mr. Sheehan, please.
Thank you. Can you state your full name for the record?
Dallas Randall Shane.
Dallas, you heard the agreement that I placed on the record, correct?
Yes.
And do you agree that the marriage was not valid and therefore that the court should grant an annulment?
Yes, I do.
And with regard to all the provisions, awarding each of you all real personal property, everything that you own is yours, everything that she owns is hers, with the one dispute of the ring. Do you understand everything that I stated on the record?
Yes, ma'am.
Do you have any questions in regard to anything that was stated on the record?
No, ma'am.
Are you asking the court to grant your judgment of annulment?
Yes, ma'am.
Okay, no further questions, Judge.
Ms. Carr, do you have any questions, Mr. Sheehan?
No, I do not.
Mr. Sheehan, did you specifically acknowledge that there was no marriage ceremony ever conducted?
There was a marriage ceremony that was conducted, but it wasn't conducted by somebody that had the license to actually conduct the ceremony. That's the issue, correct?
There was no exchange of words, Your Honor, at the end of the day. There was an agreement between myself and Ms. Borziak. And after the signatures were obtained, we both drove to the courthouse together and filed it on record right in front of the personnel at the courthouse itself. But
however, despite that,
right, there was no exchange of words. It wasn't.
There's no valid marriage.
Right.
All right. I guess if counsel for the parties both agreed, the court entered this consent judgment. I guess we don't need that factual basis. All right. All right. To again, Ms. Carr, did you have any questions, Mr. Sheehan?
No, thank you.
Questions for Ms. Borziak, please.
Thank you. Ms. Borziak, you heard the details of the judgment that were placed on the record, correct?
Yes.
And you've had an opportunity to review the judgment as well. Is that correct?
I have, correct.
And do you agree with all the terms and conditions that were in the judgment of annulment?
Yes, I do.
And did you ever appear before a minister and have a ceremony in this matter?
Oh, I did not.
Okay. And so do you agree that this marriage is invalid and void?
Yes, I do.
Okay. Thank you. I have no further questions.
Thank you, Ms. Carr. Ms. Kuhn, do you have any questions of the defendant, Ms. Borziak?
I do not.
All right, based upon the testimony that's been presented this morning and the agreement of the parties, the court will enter a judgment of annulment by consent upon presentment of that judgment.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. If there's nothing further, everyone can zoom out. Have a good rest of the day.
Thank you, you too.
Thank you, you too.
So I didn't get the full story. I mean, I guess if they agreed to it, tell you take your time. It's important that you be able to spend the entire breakfast with your daughter this morning.
Thank you. I was there, and I literally just left. Luckily, it wasn't too far away from my office.
We would have waited for you.
I appreciate that.
Were you able to stay until your daughter was recognized?
I was. It went a little
Good.
long. I was able to stay through the closing remarks. So thank you so much.
Good. All right, good. All right, the court will call the case of Austin McLeod versus Cassie McLeod. For the record, this matter is before the court, subsequent to the parties having engaged in mediation with Ms. LaPrade yesterday, I believe. Maybe it was Wednesday of this week, earlier this week. Present this morning is Attorney Rebecca Ehrenberg, representing the plaintiff Austin McLeod. Mr. McLeod is present. In addition, Attorney Kirsten Nemec is present, representing defendant Cassie McLeod, and Ms. McLeod is also present. Court is in receipt of what appears to be a consent judgment of divorce approved by the parties. Court apologized for not being present, and I'm dismayed that the other judges would not take 5 minutes to entertain the agreement of the record. But in any event, Mr. and Ms. McLeod, can you both please raise your right hand to be sworn? All right, Mrs. Ehrenberg, you can start with Mr. McLeod, being the plaintiff, please.
Thank you, Your Honor. Your Honor, considering the court has the signed consent judgment, do you need us to read it into the record or no?
Not necessary.
Okay.
If you want to just confirm with your clients that they have reviewed and read and understand the judgment and approved that that's sufficient. The court's received just a judge's copy of that judgment. But whatever your preference, Ms. McLeod, Ms. Ehrenberg, it's not necessary to go through each paragraph.
I appreciate that, Your Honor. Austin, a complaint for divorce was filed in this case. Did you have the opportunity to review it before it was filed?
Yes.
Were all of the allegations within the complaint true at the time of filing?
Yes.
Are they still true today?
Yes.
Had you been a resident of the state of Michigan for 180 days and the county of Monroe for 10 days prior to filing?
Yes.
Were any minor children born to this marriage?
Yes.
What is her name and age?
And she is 4 months old.
And it's just one child, correct?
That's correct.
And you signed yes, you signed a consent judgment of divorce in this case?
Yes.
Did you review all of the terms of that judgment?
Yes.
Do you believe that the custody and parenting time provisions of that judgment are in the best interest of your child?
I do.
And do you believe that it is a final and full settlement of all of your property?
Yes.
And do you believe that it is an equitable settlement?
Yes.
If the court were to not grant your divorce today, would you continue to live as husband and wife?
No.
Do you believe there's any chance of reconciliation?
No.
Do you understand that spousal support is going to be forever barred?
Yes.
And that means that neither you nor your wife can come back to the court and request spousal support at a later date. Do you understand that?
Yes.
And to your knowledge, is your wife currently pregnant?
No.
Do you understand that you had a right to trial in this matter?
Yes.
And that at trial you could have done better, worse, or exactly the same as this agreement. Do you understand that?
Yes.
And do you still wish to proceed with the consent judgment today?
I do.
And are you asking the court to enter that judgment?
Yes.
And do you have any other questions for me?
No.
Your Honor, I have nothing further.
Thank you, Ms. Ehrenberg. Ms. Nemick, do you have any questions of Mr. McLeod?
I don't. Thank you, Your Honor.
Questions for Ms. McLeod, please.
Cassie, you're going to have to unmute yourself. Okay. And you heard the statements that Austin made on the record concerning living in the state of Michigan and the county of Monroe.
Yes.
And to the best of your information, were those true?
Yes.
Okay. Are you currently pregnant?
No.
Did you have an opportunity to read the consent judgment of divorce that you signed yesterday?
Yes.
Do you understand it?
Yes.
Do you have any questions about it?
No.
Okay. Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anyone forcing you or coercing you to enter into this agreement?
No.
With regard to the provisions regarding Margot, do you believe that they are in her best interest?
Yes.
Okay. Do you believe that the property division is fair and equitable?
Yes.
Do you understand that once the judge signs this consent judgment of divorce, as far as property division goes, that is binding? You can't come back and ask the judge to make any changes at a later date?
Yes.
So you understand that spousal support is forever barred. You can never come back and ask the court to order that?
Yes.
Do you understand that had you taken this case to trial, the outcome could have been different?
Yes.
But rather than take it to trial, you're asking the judge to adopt this agreement that you and Mr. McLeod have made and turn it into a judgment of divorce?
Yes.
Right. Have you disclosed all of your assets?
Yes.
Okay. And are you satisfied with my representation?
Yes.
I have nothing further, Your Honor.
Thank you, Ms. Nemick. Ms. Ehrenberg, do you have any questions of Ms. McLeod?
No, Your Honor.
All right, the court's received. Look at it. Yes.
Your Honor, I just realized, I believe we may have to waive the balance of the waiting period. Is that accurate?
Yes, the divorce claim was filed on February 12th.
Yep.
And the court will, if both parties request, and they believe it in the best interest of their daughter, the court will waive the statutory 6-month waiting period. So, Mr. McLeod, there's any divorce case which is a minor child, there's a 6-month statutory waiting period from after the date the complaint is filed, which is February 12th, just to make sure there's no chance of reconciliation. But if both of you believe it's the best interest for your children, your daughter, I should say, to finalize this sooner than later, the court would do so. And if you, so you both understand that?
Yes, Your Honor.
Yeah.
Mr. McLeod, are you asking the court to enter the judgment today rather than 4 months from now?
Yes, Your Honor.
Would that be in the best interest for your daughter?
I do.
Ms. McLeod, same question for you.
Yes, Your Honor.
All right. Thank you, Ms. Neba, for catching that for the court. Now, the court's received looks like a judge's copy of the consent judgment. Will there be another copy being submitted to the court for entry today?
They were filed downstairs prior to bringing you a copy. We just wanted to make sure you had a copy when we went on the record.
Thank you. Thank you for Ms. Nemick, because it's nice to see one in front of me, but the court will look for that, and hopefully we'll sign it on base yet today. The court would like to thank and acknowledge Ms. LaPrade for fine assistance, as well as, of course, attorneys Ehrenberg and Nemick for helping facilitate amicable resolution. The court would applaud you, Ms. McLeod, one, for you can co-parent your daughter. And she will thrive because of the fact you're on the same page. And there will be bumps in the road, challenges in the future, but they can all be addressed through effective communication. So you owe it to each other and your daughter to make life good for each other. There's enough challenges in life. The court will, in fact, waive the balance of the statutory waiting period and enter the judgment of divorce today. The court will cancel and vacate the pretrial conference scheduled for May 31st at 10 a.m. since it's no longer necessary. Based upon the testimony that's been presented this morning, as well as the following this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receiving the judgment later today, the court will sign that judgment, and at that time, order that the marriage between the parties be dissolved and judgment letter granting a divorce from bonds of matrimony. Good luck to both of you, Mr. and Ms. McLeod. That will conclude this matter. You can all zoom out. And thank again, Ms. Nemec and Ms. Ehrenberg for helping facilitate ample resolution.
Thank you.
Thank you, Your Honor.
You're welcome. Have a good rest of the day.
You too. Thank you.
And
No. Mr. Beal, good morning. Did you text Stephanie?
Yeah, she don't.
Well, you should tell the judge is waiting on her. There's a phone number she can call. But otherwise, you got to jump through hoops. Got to come back to court. If you want to get things finalized, you get her to appear today. You get your divorce today. Okay. Okay, but you did text her this morning and say,
yeah,
okay.
We talked to her, said, "No, give her the money." The only time she talked to me. So she don't have anything to do. She signed the paper. She said, and that's it.
Oh, did she sign a judgment?
She said she laid everything over. 10%. I think we sent it to her.
All right. Okay. All right. Wait for Mr. Churchill.
Yeah, we had
a lot of times people do when somebody texts them, they'll appear. But you obviously want to jump through some hoops in.
Yeah, she's done it.
Doesn't matter. We have people appear from Texas. We've got people appeared from Europe. She can call. If she says I don't like computers, she can call, give her a phone number.
Well, I'm just telling you, she said she will not talk.
I'm sorry, she said
she won't talk to anybody.
Okay, so she does not want to even appear by phone today. Right. But you can maybe text her and say you can appear by phone.
She don't want anything to do with it.
All right, okay, all right. All right, court will call the case of Jesse Pavula versus Stefania Morris. For the record, this matter is before the court for a pretrial conference. Yeah, it was actually scheduled at 10:30. It's now 10:50 a.m. Ms. Morris has not appeared. Mr. Vila is present here in the first name court along with Attorney Timothy Churchill. Mr. Vila has indicated to the court that he did text his wife Stefania to appear, whether it's Zoom or by phone, and she simply does not even want to participate at all. So unfortunately, we'll require Mr. Churchill to notice up for entry a default judgment. The court file reflects that a default was entered by the clerk on April 12th, 2024. A copy of that default was also mailed to the defendant. So, Mr. Churchill, you'll then notice up for entry a default judgment. Is that correct?
Yes, Your Honor. Or if the court will allow me to submit proofs today, because we've already been in default, which still will appear at the pre-trial today, and I'll hold default. We can put proofs on today. I could just submit a default judgment.
Well, but again, but she would. I think technically she should be given a notice of a date and time that the judge will be submitted for entry. The court preferred that. I'll give you a date. I think 21 days notice by the court rule. I believe so. You can check the court rule. So we'll give you a date early June. And you can give a default judgment ready to go.
No, but I could put proofs on the record. There is an anti-nuptial.
I understand. I still want Mr. Pavula to come back here, just in case she appears. Maybe she says, I don't like something in the judgment.
Okay.
So the personal couple is shortcutting that, Mr. Churchill. So we'll give you a date to come back. The court was hoping that she would appear today because we could get Mr. Pavula divorced in the next later on today if she would appear and agree to some of these things. But if she's going to make him jump through hoops, I think we have to jump through that hoop. So we'll simply note that she's not appeared today, but the default was previously entered. But I think she has a right to see that judgment of divorce before it's entered, and along with giving a date that we're going to submit this judgment for entry on such a date. And co-sign at that time. Give her schedule for June.
I know the first week of June I've got availability.
Okay. You get that judgment off in the next couple of days, correct?
Yeah.
default judgment. And the court notes you've returned to the court today a antenuptial property agreement. Go through that detail. But we have a relatively short-term marriage of 5 years, so spousal support should not be an issue. It should be just property. And I guess when Mr. Padilla comes back, hopefully we get testimony from that she's not now pregnant. And I guess your judgment should probably reflect that to the at least plaintiff's knowledge she's not now pregnant. What's Friday, Jane? Well, it's 21 days from the date of mailing, so Ms. Churchill, assuming he gets it off, that judgment off for next week's mail.
June 13th. It's a
yeah, just the email. You've already mailed off the default. Yeah. If you just mail off the proposed default judgment along with the notice hearing saying this judgment will be submitted to court for entry on June 13th at 9:30, and with Zoom instructions. I mean, but she can, if she doesn't like appear, she can appear by phone. Okay. Well, again, the judge will enter the judgment on June 13th, and you'll get that that judgment mailed off for early next week, Mr. Churchill. Yeah. So there's no question about the time frame. Okay. So I apologize, Mr. Padilla, but we'll hopefully get this thing finalized on June 13th. All right. Thank you both. Are you related to Al? The present is Attorney Christina Hills. Our grandfather representing the plaintiff Heather Straub. Ms. Straub is present. In addition, defendant Charles Straub is also present. Good morning, everyone.
Morning, Your Honor.
The court's aware that the proofs in the partial settlement agreement was placed on the record back on March 13th, 2024. And there appear to have been 3 outstanding remaining issues of child support, spousal support, as well as defendant's interest in the marital home, which was to be reduced by $5,436. Mr. Straub, it appears that we need to move us forward to a trial date. Will you be representing yourself at that trial date?
Yes.
Okay. The last order that the court entered back in May 10th was that the parties were to exchange appraisals. Did that occur, Ms. Hills?
I think Mr. Straub had indicated he hadn't received mine for whatever reason. Yes, we did re-email those to him on May 1st. We had already received his, so there was no issue with that.
Right. Okay. Now, did you receive the appraisal from Ms. Hills, Mr. Straub?
Excuse me. Yes, I did. On the second time around, I did. Thank you.
All right. Also, Mr. Straub was to provide notarized answers to interrogatories by May 10th. Was that received, Ms. Hills?
We did get answers. They weren't entirely satisfactory, but we're not, I've spoken with my client. We're not going to be pursuing a motion to compel at this point. We believe we have what we need to move forward with trial.
All right. Thank you. Mr. Straub was also ordered to pay $520 in attorney fees to Ms. Hills by May 1st. Did that occur, Ms. Hills?
It did. Yes, Your Honor, it did.
Oh, thank you. All right. And today's the final pretrial conference. All right. Ms. Hills, what do you anticipate? We'd try this in half a day?
I believe that I can easily complete my portion of it in a couple of hours. I would have Tim Evans and my client, who I believe would be my only witnesses, and some documentation regarding income, and most likely Mr. Straub's interrogatories as my only exhibits.
Okay. And Mr. Straub, would you agree we can try this case as your main issues in a couple of hours?
Yeah, it shouldn't take longer than a couple of hours.
Yeah, are you going to call any witnesses?
I plan on calling at 3.
Okay, and who are those witnesses?
My mother, my father, and the woman who did the appraisal.
Okay, and yeah, you know the name of that appraiser, Ms. Hills?
I do. It's on the appraisal reports that he sent.
Right. What's the relevance of your appearance, Mr. Straub?
To show the value of the home, to prove forth the value of the home, in which Ms. Hills says it's worth $80,000 from her appraisals, and mine say $185,000. So there's a big discrepancy in the amount of value, and so the appraiser, I can have her come and say, basically what what comparables that she used in order to come up with her thing, and then I can have her compare it to her other, and and then I can ask why weren't these comparables used, and then why is there such a big discrepancy?
That's certainly, but the question is, what's relevance of your parents? Are they certified appraisers?
No, they witnessed and or saw and or helped me to do all of the work that I had done to the home over the last 20 years. And they can attest to that.
Well, let's assume that. But again, you've been married 12 years. So
we were together for 10 years prior to that, and I lived in the home with Ms. Straub. I purchased the home with Ms. Straub. We've lived there together for literally 20 years. We've been together since we were like 18. And over that time, I've took the house from being a foreclosure all the way to being what it is today. And it's not just the value of what it's gone up. It's also what I've done. And most of the work I've done was while Heather worked. I stayed home and repaired that home and made it a beautiful home. And we bought this home to one day rehab it and sell it together to move on to a bigger, better home. So all I wanted is them to help assess that over the last 20 years, my father gave us money for our marriage, which was $4,000 and we use it to work on the home. And I built 2 additions off of the home with using that money. So that was why he's coming I could have him assess to that. And then also my truck, when I was a kid, when we first bought the home together, I sold my truck as a young kid that I inherited from my grandfather for us to buy this home together. But for some reason, the loan only let Miss Straub be on it, or we couldn't get it. So I didn't put my name on it so we could get the home. But I was in the room with all of the signing and all of the people. And then when we got into the home, it was a foreclosure and it was water leaks and the walls were falling in and this roof was falling in. And I over the last 20 years, I've done nothing but just rehab and put all of my time and effort into making this into a beautiful home. And I've almost completed it. I'm literally almost done. There's a little couple things here and there that were the finishing touches that I never got to finish because she stopped it. But there was nothing to say that I wouldn't have completed these and finished it to be the great home, and we could sell it and both made good money.
All right, Mr. Straub. So, Ms. Hills, is there an issue in terms of the premarital value? According to Mr. Straub, they purchased the home together, correct?
This was my client's premarital home. He is not on the deed. He is not on the loan. They were not married until 12 years ago. This is her premarital property. He has done some work on the home, and Mr. Evans will have a lot to say about how the improvements that he made actually decreased the value of the home over time. Unpermitted additions, duct work coming out the middle of a soffit in the kitchen, all sorts of things that decreased the value of the home. In fact, Mr. Evans' appraisals are the same from date of marriage as today. The amounts are exactly the same.
Right. Ms. Straub wants to retain the house. Is that correct, Ms. Hills?
Yes, Your Honor.
I mean, there's always a possibility the court can simply order the home be liquidated, and it's just a matter of dividing the net proceeds. I mean, that's always an issue, a possibility, is it not?
The court can do whatever it feels is equitable. We agree the court has those powers. However, we believe that the testimony is going to show that clearly that this was her premarital property. And I believe Mr. Evans is going to be able to provide very credible expert testimony as to the value of the home, both date of marriage as well as current value. And I believe that he is going to be able to completely discredit Mr. Straub's appraiser.
All right. Okay, so Mr. Straub acknowledges Mr. Straub has some interest in the home, though, for the past 12 years, correct? And it's just a matter of she's in position to, if the court, once court determines Mr. Straub's interest in that home, she's in position to compensate Mr. Straub for his interest in the home. Is that correct?
She is, yes.
Right. All right. Okay, we'll give you a couple dates. It appears that everything is ready.
Yes, Your Honor. We also have an issue of, it goes along with the spousal support and imputation of income as to Mr. Straub. He is making a spousal support request. He is unemployed, has been for the vast majority of the marriage. He is making the spousal support claim. So I just wanted to let the court know that would be an issue related to the spousal support as well. He is not disabled in any way, shape, or form as far as we're aware.
Well, any spousal support on a 12-year marriage would be very short term, Mr. Straub, so you've got to have some testimony, documentation that you are disabled. That's the only basis in this court's opinion for spousal support. You appear to be young. Unless you've got some physical disability, you need to get your feet on the ground. This is not a spousal support case.
I have a physical disability and I can prove it through MRIs.
You need some medical testimony, Mr. Straub.
Yes, sir. Yes, sir. I can bring the MRIs that was done on my back, and then you can see the herniated discs and arthritis in my back.
Right. I need medical testimony, Mr. I need medical testimony that you cannot do any type of work. You can't be a clerk at a gas station sitting in a chair. You can't sit at a computer. There is no form of employment that you could perform. That's what the court needs. Medical testimony, not your lay testimony, Mr. Straub. So I'm just telling you, I'm giving you, you may want to consult an attorney because I think you're going to be on the short end of any claim for spousal support. In any event, we'll give you a hearing date. And the court's going to want both parties to submit just a brief summary statement. A trial brief, maybe just a couple pages, Ms. Hills, 2 or 3 pages.
Yes, Your Honor.
So we'll give some dates. When do you think you'll be ready, Ms. Hills, with your schedule?
I would just ask for the minimum 30 days, Your Honor.
It appears July 18th. I'm sorry, it's a ways off. Ms. Hills, you're available July 18th at 8:30.
I have a trial that day that I expect to go with Judge Arnold, Your Honor. I'm sorry, Judge Lohmeyer.
Okay. Maybe we can try to do it on a Monday if it's going to be half a day. Normally, the court would schedule trials on Thursdays, but I hate to put it off so far. How about July 1st? Monday, July 1st?
I hate to be the squeaky wheel here, Judge, but I am planning on being up north that week.
Fine.
I'm working, but it would be difficult for me to do a trial from up there.
Not a problem. I know you got a very hectic schedule, Ms. Hills. No need for explanation.
I appreciate that.
What about July 8th, the following Monday?
Could we do the afternoon, Judge? I have a mediation in the morning with Mr. Walker, but the afternoon is completely free.
Yes, we could.
That would be great then. Does that work for you, Ms. Straub?
Mr. Straub, it's July 8th. So it's a Monday. It'd be at 1:30. Unless you're going to be out of town, Mr. Straub.
No, that's fine.
Okay, all right. Court will notice, Mr. Straub, you're still at 131. Is that correct?
Yes, sir.
Okay, we'll mail you notice to appear. Ms. Hills, you want this in person?
I would prefer it in person if the court's okay with that.
That's fine. We'll do it in person. It'll be an in-person trial. Evidence hearing July 8th at 1:30 p.m. And Mr. Straub, you would agree the only issues are child support, spousal support, and your interest in the marital home. Is that correct? Those are only 3 issues that will be addressed.
I mean, yeah, all of the issues really. I mean, none of the issues that I've addressed.
Hold on, Mr. Straub.
Really
we put a partial settlement agreement upon the record. So
then yeah, we'll go with that. Then yeah, then we'll honor that.
All right. So the 3 issues. And the court, when they know someone in order that both parties, you need to submit a written pretrial statement or a trial summary, Mr. Straub, where we set forth your position on these issues, so the court can get some foresight. And
when would that be due, Your Honor?
What do you suggest, Ms. Sills? Would July 1st be due?
July 1st would be perfect for me.
All right. So trial briefs that due honor before Monday, July 1st. We'll put that in the written notice, Mr. Straub, written trial brief honor before July 1st. You need to provide a file original with the clerk's office, a copy to the court, and a copy to Ms. Hills. Ms. Hills will likewise provide a copy to the court and a copy to you.
Okay.
Any questions, Mr. Straub?
No, I'm sorry. Someone interrupted me. I apologize. No.
Okay. Again, it's up to you. The court would suggest that you do consult an attorney, but I know you've gone through a couple of attorneys. Anything further, Ms. Hills?
Not today, Your Honor. Thank you.
Okay, we'll see everyone back then July 8th, in-person evidentiary, 1:30 p.m. Trial briefs due on before July 1st.
All right. Thank you.
Now we'll conclude this matter. We'll see everyone on July 8th then.
Thank you. Thank you.
Okay. You're welcome. We'll call the case of Alessandro Ortiz versus Vicky Johansson. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears that both parties are present. Mr. Ortiz and Ms. Johansson, good afternoon.
Good afternoon.
Good afternoon. Court is in receipt of a consent judgment of divorce, which is wonderful. Best resolution is one which you both participate and agree upon. Mr. Ortiz, Mr. Johansson, can you both please raise your right hand to be sworn, please? Do you both solemnly swear affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I do. Thank you. We'll start with you, Mr. Ortiz, because you're the plaintiff. Can you please state your name and current mailing address for the record?
Alejandro Diego Ortiz.
Thank you. Is it true, Mr. Ortiz, you filed a complaint for divorce with this court on about February 16th, 2024?
That is correct.
Is it further true that on the date you filed the complaint that you had resided in the county of Monroe at least 10 days, the state of Michigan at least 6 months?
I'm sorry, could you repeat that, sir?
Is it further true that on the date you filed that divorce complaint, which was February 16th, that you'd lived in the county of Monroe for at least 10 days, the state of Michigan at least 6 months?
Yes, that is correct.
Is it further true that you married Vicky Johansson on July 24, 2021, and you separated in January of 2024?
Correct.
Is it true there's been a breakdown of your marriage relationship?
Yes.
Have the objects of matrimony been destroyed?
I'm sorry?
Have the objects of matrimony been destroyed?
Is that referring to the rings or the yes?
Marriage.
Yes, it has.
Your marriage.
Yes.
Is there any chance for reconciliation, Mr. Ortiz?
No, sir, there is none.
Okay. Were there any children born or adopted during your marriage?
No, there was not.
And you signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Yes.
All right. Mr. Johansson, can you please state your name and current mailing address, please?
Vicky Emily Johansson.
Thank you. Mr. Johansson, did you hear the testimony of your husband this afternoon?
Yes, I did.
Was his testimony true and accurate to the best of your knowledge?
Yes, sir.
Are you currently pregnant?
No, I am not.
And did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I did.
Okay, I'm going to walk through the terms of this with both of you to make sure that we're on the same page. You've agreed that spousal support is not awarded, and that's forever barred. You've already divided your personal property, so this judgment provides that each is awarded the personal property currently in your respective possession, free and clear claiming part of the other. There are no joint debts to be divided. Each claim debts in their own name. Each will keep their own automobile. Actually, there's a vehicle addendum attached, and it indicates that the Mr. Ortiz is awarded the 2021 Buick Encore, and Mr. Hanson is awarded the 2018 Chevrolet Colorado. Each will pay any debt thereon and hold the other harmless for any liability therefore.
Mm-hmm.
There is also a debt addendum. It references that the defendant, Vicky, will pay a debt to Ally Financial, approximate balance $22,500. Is that debt just in your name?
That is currently in both of our names, but I will be changing it over, so it'll just be my name here shortly.
Okay, so there is a debt to be divided. So I'm going to modify his judgment. Debts are divided.
It has been my...
attached.
Oh, sorry.
I should check the box and say debts are divided according to the attached debt addendum, which says you will pay the Ally Financial, because that's in both names, correct?
For now, I just have to refinance it to have him off of it. It's been my sole financial responsibility since we acquired the vehicle.
Okay. Well, I'm going to modify this and I'll initial it.
Okay.
There's only one joint debt, and that's the Ally. Is that on the vehicle?
Yes, indeed.
And you will pay that, and you'll also refinance to get Mr. Ortiz's name removed from that debt, correct?
Yes, it's an agreement that we both made.
Okay, there's no time frame, but the court will assume it's a reasonable time frame that you'll refinance it?
Yeah, absolutely.
Okay. And your credit is sufficient that they will refinance in your own name?
Yes, my credit score is great, so it should be no problems whatsoever.
That is the only joint debt, correct?
Sorry, say that again?
That is the only joint debt?
Yes, sir.
Very well. There's no real property to be divided, and there's no pensions or retirement plans to be divided. And that is it. Do you have any questions, Mr. Ortiz?
No, sir. You said there was, I think the only question you said there was no time frame on the refinancing, correct?
Correct. You didn't specify one in the judgment. So if it became an issue, the court would take the position that it's a reasonable time frame. So presumably that should be done within 60 to 90 days, Mr. Hanson, even though there's no time frame. If you didn't do that, Mr. Ortiz brought you back to court. That's how the court would interpret it, even though there's no specific time frame.
Okay.
So obviously, once your judgment of divorce, you want to start that process as soon as possible. Don't wait a couple months, because that's going to affect the credit record of Mr. Ortiz in terms of borrowing other monies. And that the title to that vehicle is only in your name. Is that correct?
Yes.
Okay. Mr. Ortiz doesn't need to sign off the title or anything?
No, he should not. No.
Okay. All right. Ms. Johansson, do you have any questions for the court?
No, I'm very good. Thank you.
Very well. Based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Judgment has been signed, a copy mailed to both of you. That will conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you. You as well.
Conference, the same as being conducted via Zoom. Are you John Anthony Settles?
Yes, sir.
Have you tried to reach out to Christina? I understand you've been separated since 2016, but if you don't get her to participate, you're going to have to jump through some hoops or incur the expense of hiring an attorney, Mr. Settles.
Actually, I just found out she thought it was next month. She's dealing with a death in the family, according to what I've been told, and she's currently in the process of getting the Zoom and getting into the chat. She's still trying to figure it out.
Okay.
With what I was just told.
And if she cannot, if she has difficulty, we give her phone number. She can appear by audio.
I have her phone number. If you guys can dial that.
Oh, she's got to call us because we're on the record. I can't just call her on the phone. If you if you have a piece of paper and pen, you can write down her phone number. If she's having problems with maneuvering on Zoom.
Okay. How would she call the court?
Got a piece of paper and a pen. We mailed out instructions, Mr. Dawson. We mailed out instructions. Other than we didn't put them in red.
Okay, I got it.
Do is read them.
I have it. Thank you. Give me one moment. See if I can transfer that over to her.
And we did mail her a copy as well, so she'd have those.
Yeah, and she acknowledged that she did receive that as well. So.
Okay, are you still receiving public assistance?
I am on disability, but I am not receiving any funds at the moment.
Okay, well, you look like you're employed.
I am employed. Yes, correct.
Asking this, Mr. Sells, there's a $175 fine fee that needs to be paid. So that's something you need to discuss with Christina. If she's not willing to pay it, then you need to pay that. The taxpayer should have to pay the complaint filing fee. And that's going to be part of any settlement here. The payment $175. So I'm just giving you a heads up. You can.
That's fine. If it needs to be paid, I got no issues with that.
Okay. Again, you can pay cash. You got to come into the courthouse. You got to pay a lump sum. The other alternative, you can call the clerk's office and pay it with a credit card, but they're going to charge, I think, a 3% fee.
That's fine.
Okay. Do you want to? We'll give you the phone number for the clerk's office, and you can call them and tell them it's a filing fee. You got the case number there. Tell them it's on this case number. You got it in your paperwork there to pay the $175 filing fee. And we'll give you the direct number for the clerk's office. Make it easy for you. Do you have a pen and a piece of paper there, Mr.?
I have the clerk's office number. That's not an issue.
Okay. All right. So, okay. Yeah. We got someone calling in. Christina Settles?
Yes.
All right. The court will call the case. of John Settles versus Christina Settles. This matter is before the court for a pretrial conference. Same is being conducted via Zoom. Plaintiff John Settles is present in audio. Defendant Christina Settles is present in audio. Ms. Settles, is your address still 3?
Yes.
Okay, good. We just want to make sure you have a valid address. The two of you have a 13-year marriage where you've been separated for the past 8 years, since November 2016. Is that correct?
Yes.
Yes.
Okay, the court mailed to Mr. Settles as plaintiff a form judge trying to make things easy as possible. In the thing, Mr. Settles, I think you said you completed that and you sent that, you mailed that to Christina. Is that correct?
That is correct.
Ms. Settles, did you receive the form judgment of divorce? It's a 2-page fill-in-the-blank form. Did you receive that?
Yes.
Okay, is there anything at issue? Do we have to, are we arguing over any property or any joint debts?
Negative.
What I have now, I got after we've already been split up.
Okay, I didn't quite say that. Ms. Settles, is there any issues of dispute? Do we have to, are we arguing over property or an outstanding bill?
Negative, sir.
Okay, what's preventing us from getting a judgment of divorce entered? Ms. Settles, you received the judgment from Mr. Settles, and have you gone through that? Do you have questions or problems with it?
So I received a paper that stated that we didn't have, that neither owned any property, and I was going to call in and try to find out what I should do, because since we had been separated, my father passed away and I inherited his home. So I didn't want to sign something stating that stated that I didn't own property when I do now.
Ms. Settles, we're talking, inheritance is something different. If you inherited it, it's not the marital property. The question is, do you have any marital property? Do you own a house together? Do you own bank accounts together? Do you have joint debts together?
No, sir.
And obviously, Mr. Settles, you're not looking for part of that inheritance, are you?
No, sir.
I'm sorry, sir.
The court asked John Settles whether he had any claim on your inheritance. He said no.
Okay. I'm sorry. It was a little hard to hear it.
Okay, so you need to look through that judgment. Do you want to walk through it with you together? I mean, if you have any questions about it, you just put, no, there's no joint debts. We don't own the real estate together. You need to sign your name and date it to the bottom, and then get it back to Mr. Settles so he can return to the court. Until the judge signs that, you're not going to be divorced.
Okay.
And Mr. Settles, the address on the judgment. Ms. Settles, are you still there?
Yes, I am.
Okay. Mr. Settles, you agree that there's nothing at issue, correct?
There is nothing at issue. All she should need to do is sign that document and send it back.
All right, Mr. Settles, do you understand that?
Yes, sir.
Okay, can you do that like today or tomorrow while it's fresh in your mind rather than waiting a couple weeks?
Yes, sir.
Okay.
I can send it to notary man. I can send it tomorrow.
Move these cases along. That's why the court scheduled us, because of when the case is sitting there. All right, so what the court's going to do is take some brief testimony from both of you to establish there's no children, and Ms. Settles not now pregnant, and then all you got to do is get that judgment to the court, Mr. Settles, when the court signs that, and you'll be divorced. Now, of course, the court will mail you out a copy of that, but you need to also, I'm going to put language in the judgment, you're going to pay the filing fee. When do you think you can pay that? Can you pay that by end of May, or do you need the end of June to pay that?
I could most likely get that sometime in the next 2 weeks.
If we gave it to May 31st, would that work?
You said May 31st?
Correct, that's 2 weeks from today, or do you need more time than that?
No, that should be fine.
All right, so I'm making a note here, and I'm going to put that in the judgment. And so make a note. You can call the clerk's office, $175 filing fee on before May 31st. If you can't do that, you call the court, and I'll give you a couple more weeks. Just don't blow it off. We blow it off, that's when bench warrants issue. We don't want to go there, Mr. Settles.
Yeah, that's not an issue.
All right, Mr. and Mr. Settles, can you both please raise your right hand? Thank you. We'll start with you, Mr. Settles, because you're the plaintiff. You can you please again state your name for the record?
John Anthony Settles.
Thank you. Mr. Settles, is it true that you filed a complaint for divorce with this court on about February 20th, 2024?
Correct.
Is it further true that on the date you filed that complaint, you had lived in the county of Monroe at least 10 days and state of Michigan at least 6 months?
I'm sorry?
Is it true that on the date you filed that complaint, you had lived in the county of Monroe for at least 10 days and state of Michigan at least 6 months?
This is a true statement.
Is it true that you married Christina Stapleton, now known as Settles, on November 19th, 2010? You separated in November of 2016.
This is correct.
Is it true there's been a breakdown of your marriage to the extent that the obviously matrimony has been destroyed? There's no chance of reconciliation.
This is correct.
Were there any children born or adopted during your marriage?
Negative, sir.
Do you have any questions for the court?
I do not.
Ms. Settles, could you please state your name for the record?
Christina Lynn Settles.
Ms. Settles, did you hear the testimony this afternoon of your husband, John?
I'm sorry?
Ms. Settles, did you hear the testimony this afternoon of your husband, John?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Do you have any questions for the court?
No.
Okay, so Mr. Settles has checked the different boxes in that judgment, and you see that, correct? And he assigned it, the bottom of page 2, is that correct? Ms. Settles? Are you still there? Okay, it's a 2-page judgment. Mr. Settles assigned the bottom of page 2, is that correct?
Yes.
Okay, so you need to sign your name next to that and date it. Then you need to mail it back to Mr. Settles so we can return it to the court. Once it's been submitted to the court will sign it, and you'll be mailed a true copy.
Okay.
And you can see on page 2, there's a blank if you want your former name of Stapleton restored to you. You see that?
I was going to actually ask, can I be put back to Legg, L-E-G-G?
Yes, you need to fill in that blank. Your former name restored, you put in that name, and then when you get the judgment, you take the Secretary of State or Bureau of Motor Vehicles and Social Security, and that will facilitate the legal change of your last name. So I wanted to point that out to you, okay?
Okay.
Do you have any other questions for the court, Ms. Settles?
No.
Can you sign your name today and get off in the mail in the next couple of days?
Yes, sir. I can have it in the mail tomorrow.
Okay. And Mr. Settles, when you see that, drop it off the courthouse. Or on a weekend, if you're up here in Monroe, there's a drop box outside the court, so you can leave in that drop box. Put an envelope, put Judge Braunlich on the outside.
This is correct.
So hopefully we'll get that sometime next week, and also again pay the filing fee, $175 on it before May 31st, Mr. Settles. Do you have any other questions, Mr. Settles?
I do not.
All right. Based upon the testimony that's been presented this afternoon, as well as the complaint filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obviously matrimony had been destroyed. There's no reasonable chance for reconciliation. Accordingly, upon the receipt of the consent judgment approved by both parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce from bonds matrimony. Unless either of you have any questions, I will conclude this hearing. You can both zoom out.
I have no questions, sir.
All right, Ms. Settles?
I have no questions.
All right, no need for you to appear again. Just get that judgment approved and signed. Get it back to Mr. Settles so we can deliver it to the court, please.
Yes,
all
sir.
Right, that concludes, man. You can both zoom out. Have a good rest of the day.
You as well, sir.
You too.
Thank you. Yeah, just having a real track of people. George versus Samuel George. Nice on the record. This matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears we have both parties present. Good afternoon. You're Sarah George. Is that correct, ma'am?
Yes.
And sir, you're Samuel George. Mr. George, can you unmute yourself so we can hear you?
There we go. Got it. Yes, I can hear you, sir.
Okay. All right. Can you both please raise your right hand to be sworn, please?
Yes.
Yes.
Thank you. All right, we'll start with you, Ms. George, because you're the plaintiff. Can you please state your name and current address for the record, please?
My name is Sarah George.
Thank you. Ms. George, is it true that you filed a complaint for divorce with this court about to February 2024?
Yes.
Is it further true that on the date you filed the complaint that you had resided in the county of Monroe for at least 10 days, the state of Michigan at least 6 months?
Yes.
Is it further true that you married Samuel George in September? I don't know what year.
2009.
I'm sorry?
2009.
2009, then you separated in July of 2023, is that correct?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the opposite matrimony has been destroyed and there's no reasonable chance of reconciliation?
Yes.
Were there any children born or adopted during your marriage?
No, sir.
Are you currently pregnant?
No, sir.
Is it true that you signed your name to this proposed judgment proving the terms and conditions contained therein?
Yes.
Do you have any questions for the court?
No, sir.
Thank you. Mr. George, can you please state your name and current mailing address?
Yeah, my name is Samuel David 161.
Mr. George, did you hear the testimony of your wife, Sarah, this afternoon?
Yes, I did.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I did.
Okay, I'm going to walk through this with both of you. You've agreed that spousal support is not awarded. It's forever barred. You've already divided your personal property, so each will keep the personal property currently in your respective possessions, free and clear any claim of the other. There are no joint debts, each paying debts in their own name. There are no motor vehicles to be divided. If there are, each keeps their own. No real estate, no retirement plans or pensions to be divided. And finally, Ms. Sarah is requesting restoration form name to that of HURD, H-U-R-D.
Yes.
Okay, and of course, when you get a copy of this judgment, Ms. Sarah, you need to take a copy to the Secretary of State and Social Security to facilitate that legal change of last name, okay?
Okay, thank you.
Okay. Do either of you have any questions?
No, I do not.
Very well. Based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter granting a divorce from bonds of matrimony. The court has signed the judgment. You both have mailed a copy. Good luck to both of you. That will conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you very much.
Thank you.
You're welcome. We're good. We'll call the case of Jennifer Grego versus Nicholas Grego. For the record, this matter is before the court for continued pretrial conference subsequent to mediation. Present for this Zoom mediation is Attorney Christina Hills, representing the plaintiff Jennifer Grego. Ms. Grego is present, and in addition, Attorney James Petrangelo is present, representing the defendant Nicholas Grego. Mr. Grego is present on audio. Ms. Hills, Mr. Petrangelo, the parties been able to make progress toward their own agreement and resolution?
We have made some, what I believe to be some substantial progress today, Your Honor. We still have a bit of work to do. I have a couple of subpoenas, which I am going to be issuing to a couple of different unions, one of which we know Mr. Grego works for, just to satisfy my client and myself that there are not other retirement benefits out there that we're unaware of. And also, there's been a proposal, which Mr. Grego has made, that my client needs a bit of time to think about. So what we did is agree to mediate again with Ms. LaPrade. Now the date's escaping me, June 27th, I believe, at 8:30 or 9. And hopefully by then I should have all of that subpoenaed retirement information, and my client will have had some time to think about this proposal. And I'm certain that Mr. Petrangelo and I will have some communication in between to see what else we can resolve even in advance of mediation.
I agree with everything counsel has stated on the record.
Thank you. So you simply want to continue this pretrial conference to June 27th after the 8:30 mediation with Ms. LaPrade?
Yes, please. And we are prepared to offer proofs for the court today as well. We'll have had some time to think about this proposal, and I'm certain that Mr. Petrangelo and I will have some communication in between to see what else we can resolve even in advance of mediation.
I agree with everything counsel has stated on the record.
Thank you. So you simply want to continue this pretrial conference to June 27th after the 8:30 mediation with Ms. LaPrade?
Yes, please. And we are prepared to offer proofs for the court today as well.
Okay. And if in fact there's some resolution in the interim and you cancel the mediation, there's no need for the parties to come back and appear before the court if we preserve the proofs today.
Sounds good. Thank you, Your Honor.
The court will mail out notice until we have a full resolution. All right, Ms. Grego, can you both please raise your right hand to be sworn? All right, Ms. Hills, if you're going to go with Ms. Grego to establish jurisdiction, there's been a breakdown and that she's not now pregnant, please.
Yes, Your Honor. Ms. Grego, would you state your name for the record, please?
Jennifer Grego.
And you are the plaintiff in this case, is that correct?
Correct.
And at the time you filed your complaint for divorce, had you been a resident of Michigan for at least 180 days?
Yes.
And of Monroe County for at least 10 days?
Yes.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes.
You and Mr. Grego have one minor child, Sophia, who is 14. Is that correct?
Correct.
And there were no other children born or adopted by you and Mr. Grego who are still minors. Is that correct?
That's correct.
And are you pregnant?
No, I'm not.
All right. Thank you. I have nothing further.
Thank you, Ms. Hills. Mr. Petrangelo, do you have any questions, first of all, from Ms. Grego?
I do not.
Questions for Mr. Grego, please?
Yes. Mr. Grego, have you heard your wife's testimony today?
I have.
Is it true and correct to the best of your knowledge?
It is.
I have no other questions of my client.
Thank you, Mr. Petrangelo. Ms. Hills, do you have any questions for Mr. Grego?
None at this time, Your Honor. Thank you.
Okay. The continuing mediation is 8:30 or 9 with Ms. LaPrade?
9.
9 o'clock.
9.
Thank you.
All right.
Okay.
All right. The court will mail a notice of a continued pretrial conference subsequent to the 9 a.m. mediation with Ms. LaPrade, June 27th. Mr. and Mrs. Grego, you're both represented by two very capable, skilled family law practitioners. And they're assisting you into trying to facilitate and reach your own agreement, which is, I can assure you, is far better off than having the court decide these issues. So keep an open mind and follow the advice of your capable attorneys as you continue this mediation process on June 27th. Based upon the testimony that's been presented this afternoon, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will simply reserve all outstanding issues and schedule this matter for continued mediation June 27th, 9 a.m. with a pretrial to follow.
Great.
If there's nothing further, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
All right. Thank you very much, Your Honor, and have a good weekend.
Thank you.
Thank you both. Subsequent to mediation with Ms. LaPrade from the front of the court, this hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff Jennifer Grego. Ms. Grego is present. In addition, Attorney James Petrangelo is present, representing the defendant Nicholas Grego. Is Mr. Grego? There's Mr. Grego. Mr. Grego is also present. Good morning, everyone.
Morning, Your Honor.
Morning.
Have the parties made any progress in mediation this morning?
We did, Your Honor. We have an agreement we'd like to place on the record.
Please, Ms. Hills, if you want to proceed with that.
Yes, Your Honor. Your Honor, the parties have one minor child who is 14 years old. They've agreed that they will share joint legal custody of their child. Parenting time for Mr. Grego is going to be reasonable and liberal. Holidays are going to be as agreed or the friend of the court holiday schedule in the absence of an agreement. Child support is going to be reserved. There is a significant deviation, which I will address in the real estate section of this agreement. The tax exemption for the minor child is going to go to Ms. Grego each year. Uncovered medical expenses for the minor child are going to be divided such that Mr. Grego is paying 90% of those and Ms. Grego is paying 10% of those. Spousal support is going to be barred, as to Mr. Grego. Mr. Grego is going to pay Ms. Grego non-modifiable spousal support in the amount of $2,400 per month for 9 years or 108 months, commencing August 1st, 2024. That will be terminable only on the death of either party or Ms. Grego's remarriage. Parties have agreed that their daughter will attend high school until further order of the court or agreement of the parties. Tuition is agreed to be paid each year that the child continues to attend, 80% by Mr. Grego and 20% by Ms. Grego. Ms. Grego is going to have exclusive use of the marital home as of August 1st, 2024. She may continue to live in the marital home for 4 years until the minor child graduates from high school in May of 2028. In lieu of child support during that time frame that she is still living in the home, Mr. Grego is going to be solely responsible for the mortgage payment, utilities, taxes, and insurance on the home, as well as the ordinary maintenance costs for the home. So that is the reason for the deviation on the child support. The house is going to be sold and the net equity split equally between the parties at the latest the summer of 2028, following the child's graduation. That would be at the latest. Parties do have an opportunity, if things don't work out quite the way they think they're going to in the next 4 years, to sell the house earlier than that, in which case they would each notify friend of the court, and the court would then conduct a child support investigation and make a recommendation as to a start date as well as an amount of child support to be paid at that point. The parties are going to split their bank accounts equally after payment of a credit card, an Amex card, in the amount of $5,927. So that would be paid first, and then the net balance of all of their bank accounts would be split as of August 1st, 2024. There is a Raymond James investment account, which will also be divided equally between the parties by August 1st, 2024, or earlier as agreed, and each party would be responsible for any capital gains tax on the portion retained by him or her. With regard to retirement benefits, Ms. Grego does not have any. We are still in the process of nailing down all of Mr. Grego's retirement benefits. He is an electrician, so he has a number of benefits that are scattered among different electrical unions and electrical associations, we believe. So she is going to receive 1/2 of the marital portion of any retirement benefits which he has accrued during the marriage, including but not limited to NEBF, IBEW Local 8, and the Henry F. Teichman, that's his current employer, defined contribution account through capital funds. So she'll receive 1/2 of the marital portion of all of those and any that we are not aware of as of yet. Ann Pastrana would prepare any necessary qualified domestic relations orders. The cost of those orders would be split equally, as well as administrative costs required by the plans would be split equally. Each party would pay their own attorney fees. My client is not asking for her maiden name to be restored. I think it goes without saying with her having exclusive use of the home as of August 1st, 2024, but he will vacate by August 1st, 2024. Ms. Grego is going to keep the Cadillac XTS and any debt associated with that vehicle. Mr. Grego would keep the Dodge Ram and any debt associated with that vehicle. We'd include standard hold harmless language. Personal property, they have agreed to divide on their own as they agree. Marital debt, they are each going to keep what's in their own name with the exception of the Amex card, which I mentioned with the split of the bank accounts. And the Amex card is not to be used any longer. And again, is to be paid, as I mentioned, from off the top, basically, of the balances of the bank accounts. I believe that is the entire agreement.
Thank you, Ms. Hills. Mr. Petrangelo, did Ms. Hills accurately state your client's agreement?
Yes, Your Honor. It may have been said, but we've been paying, primarily Mr. Grego paying expenses on a status quo basis. That'll continue until that August 1st commencement date. And thereafter, of course, his contributions to Mrs. Grego will be the spousal support and his payments toward the home.
That's correct.
Very well. Thank you, Mr. Petrangelo. And Mr. and Mrs. Grego, can you both please raise your right hand to be sworn, please? Mr. Grego?
Yes, sir.
Thank you.
I do.
Thank you. Okay, put your hands down. Ms. Hills, you can begin with Ms. Grego, please.
Yes, Your Honor. Does the court have record of us taking proofs last time we were here?
Yes, we did on May 17th, so you can simply update the proofs, just confirm with Ms. Grego she's not now pregnant. That's the only thing, remaining thing to be updated, Ms. Hills.
Okay. Yes, Your Honor. Ms. Grego, would you state your name for the record, please?
Jennifer Grego.
Are you pregnant at this time?
No, I am not.
Have you heard the settlement agreement, which I've just placed on the record and has been clarified by Mr. Petrangelo?
Yes.
Do you understand all of its terms?
Yes.
Do you have any questions about it as you sit there right now?
No.
Have you had enough time to think through all of these issues?
Yes.
We've mediated twice now with Ms. LaPrade, is that correct?
Yes.
And you've been an active participant in both of those mediations?
Yes.
Right. You understand that spousal support as to Mr. Grego is barred, meaning he could never come to court in the future and ask you to pay him spousal support. You understand that?
Yes.
He is going to be paying you non-modifiable support. You understand that?
Yes.
And that means that neither one of you would be able to come into court in the future under any circumstances and ask it to be modified, that it be increased or decreased, or that the time frame be lengthened or shortened.
Yes.
All right. If we had gone to trial with the court on that issue, the court only has the power to order modifiable alimony. Do you understand that as well?
Yes.
All right. And you are voluntarily agreeing that the spousal support be non-modifiable?
Yes.
All right. You understand we could have had a trial as to all of the issues, including spousal support, and by entering into the settlement agreement, you're waiving the right to a trial?
Yes.
Right. And you are not asking for restoration of your maiden name, correct?
Correct.
Right. Are you satisfied with my services on your behalf?
Yes.
Are you asking the court to grant you a divorce?
Yes.
Right. Have you disclosed all of your assets and liabilities during the course of negotiations in this case?
Yes.
Right. I have no further questions.
Thank you, Ms. Hills. Mr. Petrangelo, do you have any questions, first of all, for Ms. Grego?
I do not, Your Honor.
Questions for Mr. Grego, please.
Yes. First of all, Mr. Grego, have you heard your wife's testimony today?
Yes.
Is everything she said true and correct to the best of your knowledge?
Yes.
Sir, have you heard the settlement placed on the record today?
I have.
Do you understand it?
I do.
Are you in agreement with that settlement?
Yes.
You understand, as has been explained to your wife, you are entitled to a trial. Judge can come up with something totally different than this. Might be better for you, might be worse. and you are now giving up your right to have that trial.
Yes, I understand.
And, sir, men can receive spousal support, and that is something, there are no facts before us that would cause us to think you would be awarded such, but you are still giving up that right. Do you understand that?
I do.
And as to spousal support, the court would impose a modifiable amount. It could be more, could be less, it could last forever. And by entering this agreement, you are locking into a set figure, and you can't ask for a change no matter what happens to you. You understand that?
Understood.
And do you agree to that?
I do.
Sir, are you satisfied with my services as your attorney in this matter?
Yes.
Have you had enough time to think about all of this?
Yes.
Are you asking the court to adopt this as a final agreement today?
Yes.
Have you fully disclosed your assets and liabilities in these negotiations to the best of your knowledge?
Yes.
I have no further questions of my client, Your Honor.
Thank you, Mr. Petrangelo. Ms. Hills, do you have any questions of Mr. Grego?
No, Your Honor. Thank you.
You'll prepare the judgment, Ms. Hills?
I will.
The court notes this is a 20-year marriage. Ms. Grego, is there any chance of reconciliation?
No.
No? That's most unfortunate. You've worked hard for the last 20 years. In any event, based upon the testimony that's been presented this morning as well as previously, and the complaint filed in this case, court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and unfortunately there appears to be no reasonable chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court would like to thank Mr. Pratt for finding continuing assistance and helping facilitate resolution, as well as, of course, Attorney Hills and Petrangelo. And the court would applaud you, Ms. Grego. Without question, the best resolution was one in which you both participate, as you have to mediation and reaching your own agreement. Far better off than have the court decide these matters after a trial. So with that, good luck to both of you. You can both zoom out and have a good rest of the day.
Right. Thank you, Your Honor. You too.
You're
welcome.
Thank you.